think the biggest myth, especially related to IP, is that um, that you can protect everything, and that's wrong because you just simply can't. You can't protect everything. You can't draw a box around everything that your company needs to do business, because some of that information has to be shared. It has to be released to your business partners in order for your business to function.
Hey everyone, this is Devin Miller here with another episode of The Inventive Expert. I'm your host, Devin Miller, the serial entrepreneur that's grown several startups into 7- and 8-figure businesses, as well as the founder and CEO of Miller IP Law, where he helps startups and small businesses with their patents and trademarks. You ever need help with yours? Just go to strategymeeting.com, grab some time with us to chat, and we're always here to help. Now, today we've got another great guest on the podcast, Angela Thurman. And today we're going to be talking about one of the topics that's especially near and dear to my heart, which is intellectual property. A bit more specifically, we're going to be talking about the exporting of intellectual property, contracts with IP clauses, and also dealing with NDAs or non-disclosure agreements, protecting the IP of your clients, not just your own IP, how a lot of clients are not particularly careful with their IP, and maybe even talking a little bit about IP tracking and what that might mean for yourself or your clients. So with that much as an introduction, welcome on the podcast, Angela.
Thank you, Devin. I'm pleased to be here. Thank you for having me back.
Absolutely. And for those that haven't had a chance, so Angela was on the Inventive Journey as a guest. So if you'd like to go and check out her episode, definitely invite you to do so. Great journey to hear. Now, for those of you that haven't heard that episode or just wanting to or get just a quicker snippet introduction, go ahead and introduce yourself to the audience, Angela.
Okay, I'm Angela Thurman. I am the owner of Thurman Co. We are a project management, contract management, and supplier management consulting firm in Houston. I have a team of project management consultants across the USA, and we have contractors that provide specific expertise internationally as well. And we're ready and able to help you with all your project management needs.
Awesome. Well, that's a great introduction, and certainly is a fun company to be involved with. So,
Yes.
well, with that, now is diving into a bit of the topics at hand. So one of the topics that as I mentioned, I have a bit biased, but near dear to my heart. But I think that also has a lot of impact is kind of the idea of exporting of IP and kind of help maybe help the audience understand a little bit of what that means and why that might be of interest to them.
Okay, yeah. So I have a long history in technical project management, particularly around aerospace and telecommunications. So I've worked with a lot of technology that has been developed or invented in the United States that has then been expanded to manufacturers, particularly contract manufacturers overseas. And one of the things that we're particularly cognizant of is how the documentation, even if it's even just in a meeting, how that information is shared with our partners, whether it's in the United States or overseas, but how we share our intellectual property and what is intellectual property, and how you work on a project with a team, but still remain cognizant of the intellectual property and protect the IP of either your own company or your customer, and so forth.
No, and I think that's a great topic and something to be aware of. And if I were to maybe summarize that, basically, hey, let's say you're a company in the US, you have some great ideas. Now you start to go abroad, and that can be to do with manufacturing. It can be doing with sales, expanding into footprint. And so as you're going abroad, one of the things you often do is as you said, export your idea. In other words, or IP, in other words, your ideas, how you do it, manufacturing, if you're getting, sales and marketing and all those things. And
Yes.
while it's part of the expansion process, if you're not careful, you can give away a lot of the secret sauce or the information relevant to your business that will be helpful to people that are either competitors or that will become competitors because you share your ideas. So now, on the other hand, if you don't want to get stuck in the paralysis of, well, I don't want anybody to ever rip off my idea, or never copy it, so I'll just stay in the US and I'll never expand. Sometimes that's fine if your market's all in the US, but if you are looking to expand, how do you go about, kind of, is it an NDA, and every country is different as far as whether they even have NDAs or whether they respect them, or is it more of tightly controlling it or watching what you disclose to them, or how do you go about, as you're kind of are going abroad or otherwise looking at different countries for the various reasons, how do you go about protecting that as best you can?
Well, I think that the NDA, or the non-disclosure agreement, is the first step in protecting your intellectual property, regardless of whether it's in the US or outside the US. Um, I I have a non-disclosure agreement that I employ whenever I begin a partnership of any kind. And that protects, it's bilateral, and it protects both sides. So I want to have that in place before we start having any formal discussions about any kind of project or product. And that just sets the groundwork to say, we're going to be in agreement that we're going to deal fairly with each other, and we're going to each protect the other's intellectual property. And as soon as that NDA is in place, I begin an IP disclosure tracker. So what is the date? Who was the recipient of this disclosed information? Where is that information now going to be archived, and so forth? And then that lives indefinitely. So even if at some point your project is concluded and you agree that the information that has been shared is now going to be either returned or destroyed, the tracker itself will continue to exist, because that in and of itself is not intellectual property. It's just the tracker. And I so I have a template for this. All my PMs use this tracker, and that is a standard form for all of our projects. And it's just good project management to have such a template.
So now maybe just one follow-up question to that, which is, okay, so track all this information, have a pretty good idea of what I've disclosed, who I've disclosed it to, kind of what is that intellectual property. What do I do with it then? In other words, it does, as far as I'm aware, and you can correct me where I'm wrong, it's not legally binding. In other words, you're not going to say, hey, because I've tracked this IP and I know I disclose it to you, it automatically protects me, or I'm safe, or I'm good. Now, it can be helpful in tracking down and saying, here's the information. This should be covered under NDA, or this is under, or has other intellectual property, such as patents or trademarks or anything else. So it's definitely helpful. So is it just mostly just to have a record for in case they break an NDA, or do you do anything else with it, or kind of, or what's the utility of it?
It's a good record, and having that record of when and where and by whom the IP was disclosed and to whom. And so if at some point it becomes a question, you've got the evidence.
No, and I think that that's a great point. I mean, first of all, a lot of times, most companies, even whether it's US or abroad, they aren't trying to go out and wreck the business. They're not trying to go and rip things off. Now, they may not realize that you disclose this or is confidential. And so I think that, in the one hand, even be well before you get to the legal avenue, you can oftentimes kind of head off a lot of those issues, because you're saying, hey, remember, we provided this details to you, this is confidential, you can't disclose this to anybody else, and that may resolve the issue. But then I do think, having that trail and that record also does help in, or if there is an IP issue, or there is something where they are utilizing and using the information you disclose to them, it can give you an ability to, as needed, show it in court or otherwise enforce that. Now, one of the other things that we talked a little bit about is, there's kind of different types of IP, not this in the sense that patents or trademarks or that, but there's intellectual property within your own business or your own company. And there's oftentimes if you're working with other clients, which everybody has other clients, but depending on your industry, some of that is, you're also working with the intellectual property of others, meaning they are disclosing their ideas to you, or you're providing a service to them, or anything else. And so as you're working with others' intellectual property, what are any good thoughts or takeaways as to how you should help to protect their intellectual property and or cover yourself in case there ever is an issue?
One of the things is to make sure that intellectual property is clearly marked as the intellectual property of whatever company or customer, and to make sure that it's properly archived. So don't be putting your customer's intellectual property on some shared drive where just anybody can get it. And so one of the things that I remind my team that an NDA is project specific. So I may have an NDA with a subset of, let's say, some large organization, and we're working on a specific project. And the property, the intellectual property that is shared by that team may not be shared with some other team, even if it's the same organization, because you just can't cross-pollinate between teams. And so you have to be cognizant of those kinds of things. And because sometimes those teams may be competing for the same funds or the same ultimate client's business. So you have to be very careful about who knows what. Another thing is, so make sure that everything is properly marked, either confidential, proprietary, all of those words, and that everybody understands what that means. Make sure you've got your NDAs in place. You're tracking all of this. You're archiving it in the proper places, and that everyone understands. Let's say you're going to attend some sort of cadence meeting, and a new person has joined the team. Do they understand that they are under the purview of the NDA? Do they need to sign the NDA to be held accountable to that NDA? And so forth. And then it never hurts to make an opening statement, just so everyone is aware that the conversation that is held in this meeting is under the guidelines of the NDA, that everything that is said is confidential, whether it's spoken, whether it's shared in a PowerPoint presentation, whether it's written in the meeting notes. Everything is covered. And then just to follow up in some sort of transcribed meeting minutes and so forth.
So now one question, and I think that's a great explanation, and it raised to mind maybe a slightly tangential question, but one nonetheless. Sure. Is sometimes you don't want to be bound by an NDA, or in other words, if you're the client, as an example, and you are, as you said, competing for multiple different bids, and maybe it's two competitors and they're saying, hey, we don't want the same company working on this, and I even get this in the IP field, which is even if they're not a conflict from an attorney standpoint. They're just saying, hey, we just don't want to cross-pollinate. We may at some point enter into the same technologies, another one. We don't want to have that conflict. And so
Mhm.
whatever the degree is, or, the other time I see it come up is a lot of times when people are going to investors. So angel investors, venture capital, and they're saying, hey, we get pitched a lot of ideas, unless we decide to invest in that, we don't want to be restricted as to having an NDA such that we can't pursue that, or, that avenue later on with a different business that we may want to invest in. And so sometimes you get to a point where they aren't wanting to protect the intellectual. It's not like they're trying to steal it, but they're just saying we don't want to be bound under any sort of agreements or confidentiality because it will hinder our business. And so in that case, any thoughts on, should it be a red flag and you just run away and never deal with that company, or
Mhm.
thoughts on how you go about understanding that some industries don't do those, or aren't willing to enter into those type of agreements, but also getting that degree of protection that you can?
That's not an area that I'm particularly versed in, but my gut reaction is if they're not willing to sign at least some form of NDA, that's a risk that you'll have to evaluate, and each person is going to gauge it for themselves. Me, I'm a particularly risk averse type person, and if you're not, if you wouldn't be willing to have an NDA in place, I might not be willing to pursue the business with you.
Mm. Yeah, and I think, and I'll flavor it a bit just because it's an area where I've dealt with as well. And so
Mhm.
probably the one that's the best is, as I said, angel investors and venture capitalists. Those are generally, they get pitched a lot of ideas, and most of the time, if you say, hey, will you sign an NDA, they'll just flat out tell you no. And it's not because, again, not because they're trying to steal their ideas or they're trying to get access to it. They're just saying, hey, any given time, I'm going to get pitched a lot of ideas. Sometimes I'm going to pass because I don't like the founding partners, or they don't have a good enough team, or they don't have a good enough plan, or, and the X, Y, and Z. And they're saying, but doesn't mean I don't like that industry, or sometime might not invest. It's just not today. It's not this company type of a thing. So they'll just flat out tell you, some of them will sign them, most of them won't. And so
Mhm.
usually how I counsel clients on that one is more of, hey, don't go and disclose any more details than you're wanting to get out into the public. In other words,
Mhm.
if you are entering in that situation where they just, because it's not because it's the industry or because they're not willing to, then you have to or manage your risk. In other words, saying, okay,
Mhm.
then whatever I tell them is I have to treat it as it's going to be public. It's going to be in the public. Competitors are going to be aware of it. Other people could use it against me. And so then you adjust what you're willing to share, how much you're willing to share it. And then as you get further along in the relationship, as you get more confidential information that you're going to be disclosing, then you're going to revisit the issue. So sometimes it's not, hey, the first time I talk with you and meet you out of the chute, you have to sign an NDA before I tell you anything. You also need to manage or gauge, hey, for the initial few meetings or that, I need to keep a higher level. I want to be careful what I do and don't share. And then as the relationship matures, then it may transition over to, we need to have that protection.
That makes perfect sense.
So now you do that. So, we've talked through a few different things as far as, kind of exporting of IP and, contracts, and one of the ones that I think we started down, or we talked about with NDAs, but when you're dealing with contracts in general, any other clauses that people should be aware of or should be looking at or understand, you should or shouldn't have this clause in an agreement when it deals with IP. Any thoughts on that front?
Um, Foreground and background information. So I think that when you're dealing with IP, especially, you want the contract to be clear that there is a certain amount of information that you're each bringing to the table that was preliminary information. It's background information that was your information. You developed it, and that is already protected.
Mm.
Um, so so that's really important, and you may want to even describe in a little bit of detail what that might include. So I think that that's probably
Now, let me ask, and I
something.
think that definitely makes sense. And maybe one follow-up question. Again, some of these we
Mhm.
haven't talked to. I'm just curious to get your
Sure.
thoughts. I mean, one of the things that I've seen a lot of different types of NDAs and other agreements, and some of them are great, some of them are way too overly burdensome, and some are way too thin. But one of
Mm-hmm.
the things sometimes you'll see is, some agreements will say anything that we deem confidential, we have to stamp or otherwise put it in writing that this is confidential.
Mm-hmm.
And so then basically, if you don't stamp it or you don't put it in writing, this is confidential, then it's deemed as being not confidential, and it's is open to use that information how you want. On the other
Mm-hmm.
hand, I've also seen ones that are very broad and basically say anything we ever tell you whatsoever is all confidential, and anything we disclose to you needs to be treated with the highest level of confidentiality, blah blah blah, something
Mm-hmm.
like that. And both of those, one is leaves it pretty open that you're probably going to miss a document that is that you want to be or should be confidential, but you didn't mark it properly. And on the other hand, if I'm on the other side, I'm saying I don't know that every possible thing that we ever say to each other, whether it's a phone call, email, correspondence, or text or anything else, is all going to be confidential information that I can never disclose or never even think about disclosing. So how do you balance that? Or any thoughts on kind of the scope of what should or shouldn't be included as far as confidential information?
Well, I think the second scenario is borders on the ridiculous.
I've
And
seen it before though,
I
so
know,
it's
I know, so have I. But the first one I think is more common, but it does put a burden on both parties to clearly mark all of their documents, and so that does leave a little bit of wiggle room if you forget anything. And so I would be very, very careful of putting forward or sharing anything that you had not at least reviewed to make sure that you determine, number one, should this be confidential or proprietary? And number two, did we perform our due diligence to ensure that it is properly marked?
Mm.
And the trouble with that is that sometimes there are some very casual email conversations that happen, particularly down at the level of engineer to engineer. Oh, hey, Sam, can you email me that document? I don't have a copy of it from the last meeting, and it comes across and it's not properly marked. A revision, an engineer or a tech or someone sends a latest markup or even a preliminary markup that hasn't gone through all of the final document controls, and it's not been properly marked yet, and that becomes a troublesome
Mm.
area. And then also the person who's in charge of tracking all of the exchange of IP isn't made aware because it's not an official exchange. So there are lots of opportunities, shall we say, and
Yeah,
that's
and,
that's
and
that's where I always encourage, to follow the official channels, to have some sort of official conduit for the exchange of these uh, documents and information.
No, and I think what you hit on is a great idea. In other words, kind of almost goes back to the IP tracking, but even just well beyond that is just, hey, have a system in place for what are the steps and the how you go about identifying what is confidential or what is intellectual property, and then how you deal with that. And as long as most of the time, if you can have that system in place and then train people, you can catch most of the issues before they become or catch most of the would-be issues before they become issues. Now, one of the
Yes.
other things, as I've seen that on some of the agreements, and I'd have to look, and it's been a little or a long enough time I don't have it memorized, but they'll basically have something along the lines of in a contract agreement that also, in addition to anything that's marked as confidential or otherwise has those indications or is put in writing as being confidential, anything that our parties would reasonably construe as being confidential, even if it's not in writing, would also be covered under confidentiality. Now, that leaves it a bit open in the sense that you're not having a clear line definitive, and so you're still better to market as confidential, but it does kind of
Mhm.
give you a ability to argue that the other party should have reasonably understood that when I send that marked up draft that does have proprietary information in it, you would reasonably understand that, and you'd still be under duty to confidentiality. So I think that one kind of
Mhm.
straddles the line of having a bit of a catch-all. It does leave it open. You may still have to argue about it, if you ever got to it in court or with attorneys, but at
Mhm.
least it gives you a level of coverage in the event that somebody or forgets or doesn't mark something or otherwise doesn't follow the system or structures in place.
Mhm. And it's amazing the things that that we would consider confidential information that probably not all just the average person wouldn't necessarily think of. I mean, we all recognize that things like mechanical drawings or electrical systems drawings, things like that that the company owns as their designs, yes, we recognize that's a confidential drawing, confidential proprietary information. But other things are as well, like sales information, customer records, um, forecasts, recipes.
Mm.
There's, the 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 complex chemical breakdowns of formulas. All of those things are also uh, confidential, and a company will go to great lengths to protect that information. What is the exact formulation of the magenta of T-Mobile? Their brand magenta. Those kinds of things. There's just tons of things that that companies protect heavily and don't want openly shared.
No, and I think that's a great thought and a great takeaway. So, but with that, now we are wrapping towards the end of the podcast episode, and we could, I'm sure, talk about this a lot more in depth, and there's plenty of other questions we could hit on. But I think at least for the initial discussion, that it's a great place to give people a bit of expertise and a bit of introduction to it. So as we wrap up towards the end of the episode, always wrap up with one question. So we'll jump to that now, which is, within your industry, what is the biggest myth and why is it wrong?
I think the biggest myth, especially related to IP, is that that you can protect everything, and that's wrong because you just simply can't. You can't protect everything. You can't draw a box around everything that your company needs to do business, because some of that information has to be shared. It has to be released to your business partners in order for your business to function.
No, and I agree. And I think that I like how you hit on, first of all, there isn't a way that you can protect every possible piece of intellectual property that's ever out there. And even if you could, that would be a lot of time, money, and expense that you probably aren't going to get the return on. And so, but I like, it doesn't also mean that you're not able to protect those things that are core to your business or that are valuable, that are worthwhile to protect. And so I think that, almost the myth to dispel is, hey, you can't protect everything, but you can protect the things that are most important, and you need to identify those and then put systems and other things in place to work to protect those as best as you can. Even if you do all of that, still sometimes it gets out, it doesn't otherwise get protected, there are holes or gaps, and so you just have to understand that there isn't 100% perfect foolproof plan, but you're going to work to protect it as the best as possible and then operate under that understanding. So great myth to dispel and a great takeaway. Well, if people want to reach out to you, they want to be, excuse me, a customer, they want to be a client, they want to be an employee, they want to be an investor, they want to be your next best friend, any or all of the above, what's the best way to reach out to you, contact you, find out more?
You can reach me on LinkedIn. We do have a Thurman Co. LinkedIn page, or you can contact me at thurmanco.com.
Great. Awesome. Well, I definitely encourage people to reach out, connect, and otherwise engage and support a great business and also get some additional expertise. So with that, thank you again, Angela, for coming on the podcast. It's been it's been a pleasure. Now, for all of you that are listeners that are out there, if you can help us to share this expertise by going and clicking share, click subscribe, click review, and it helps us to really share this expertise with all the other startups and businesses out there that can benefit from it. And on that note, if you ever need help with patents, trademarks, or anything else with your intellectual property, you start up your small business, just go to strategymeeting.com, grab some time with us to chat, and we're always here to help. Well, thank you again, Angela, for coming on the podcast, and wish the next leg of your journey even better than the last.
Thank you, Devin.